when it came to war, there was no law against waging war before 1945. I think we have to appreciate just the Herculean task that it would have been to cross-examine Hermann Goering. So it's very easy for us to pick apart and to say, oh, why'd you say that? What Justice Jackson ran into was one of the most common errors, the unspeakable horrors of Nazi Germany. We all knew that that was wrong, but how do we hold people legally responsible for it?
One Great Case, a podcast about law to learn more about people. I'm your host, Areta Lloyd.
So there were 12 sets of trials from 1945 to 1949, and the film focuses on the first trial, which is of the 21 war criminals. And it usually does get the most attention because the defendants were some of the major figures in the Nazi Party, including Rudolf Hess, Albert Speer, and of course, Hermann Goering. And the trial opened on November 20th, 1945. It began with the reading of the indictments, and there were 4 of them. And I'll just go through them really quickly, David, and then you can definitely tell us more about them. So the first count was conspiracy to wage aggressive war, which addressed crimes committed before the war began. The second count was waging an aggressive war, or I guess sometimes it's called crimes against peace, which was supposed to cover the violation of international treaties. Count 3 was war crimes, the more traditional violations of war, such as killing of enemy soldiers and mistreatment of combatants. And count 4 was this new crime, crimes against humanity. So I will let you inform me more fully about these indictments. I think you probably are well versed in them.
I wouldn't say well versed, but I have lots to say about them because I think we really do need to recognize the challenges that the prosecutors and the parties, the 4 countries that made up the Nuremberg trials as the prosecuting countries and as the judging nations as well, the challenges that they faced. Because as a starting premise, when it came to war, right, there was no law against waging war before 1945. There have been little snippets. You kind of think about, the League of Nations that was set up in the wake of the First World War. You kind of had heard about, things such as, the Hague Convention and all these sorts of things. So there were kind of, talk about, well, we don't want to allow war, this idea of, crimes against humanity, that's something that, shouldn't be condoned and we should make people responsible for that. But you basically had a state of affairs where it wasn't illegal to wage a war at international law, right? And when you kind of think about how international law and the very sources of how international law works, it's very different than domestic law, right? Domestic law, we have, a parliament, we have a House of Representatives. I guess back in the day, it could be a king or a queen or whoever it is, right? Makes a law, parliament passes the law, the king or queen, they decree a law and so forth. And then, it's written down on the books and the courts interpret it and it's debated. And we, as I'm sure the lawyers watching this well know, some of these principles go on, or the debates and principles emerge after hundreds of years of jurisprudence and case law and all that sort of stuff. In international law, we don't really have the benefit of having, hundreds of years of courts and hundreds of years of cases or any great body out there that, passes laws that govern the entire world because our whole system is predicated upon sovereign states. So the sources of international law, even in 1945, tended to be various treaties that had been agreed to, right? So we can think of, the Hague Conventions, or now we have, the Geneva Convention and things like that, right? You could think about treaties between nations, about, trade agreements or about non-aggression pacts. Think about, Germany and the Soviet Union, the non-aggression, all those sorts of things. And then we also had customary law as well. That's a very important source of international law, right? What is the custom that tends to govern these things, relationships between countries? They were faced with this challenge about what happened in Nazi Germany was at such, a massive, unprecedented scale that had never occurred before in history, right? So not only did you have, such terrible crimes that were committed against, people in terms of extermination camps and of disenfranchising people from their civil rights or any involvement in, the political process and so forth. You also had this idea that, well, countries go to war with each other, and how are we going to, criminalize that, right?
Yeah, and that's one piece of it, right? And the other piece of it is, policing what happens in a country's own borders, right? And I think that's where, the whole concept of this crimes against humanity, but within a country's borders. And it's important to remember just how historical these trials were, and that, there were these ideas floating around well before World War II. The Turkish action against Armenians and a bunch of other actions. I mean, even look at what happened in the Soviet Union in the 30s, and so people were rightly horrified, but there was no sense that the community should be reacting in any judicial way to those horrific events. And so I find it really interesting, because I think Nuremberg is where you can see, if you read all the trials, you can see how that concept of making states responsible for what's happening in their own borders and answering to the international community starts in this first trial as somewhat weak, I would think, and then progresses to being more audacious in a way, if I may use that word, and takes us all the way to the Rome Statute of 1998.
Yeah, absolutely. I mean, if we focus, if we kind of come back to the indictment for a second, right? Let's focus on the crimes against humanity. Like you're absolutely right that, Nazi Germany had all these terrible laws that are well known that, actively permitted, discrimination, disenfranchisement, arbitrary detention, imprisonment. That was the law of the land. So how do you go back and essentially say that was so wrong, right? Even though you had a law against that, you are just going to be criminally liable because we have these grander principles internationally speaking. So how do you retroactively go back and create a crime for something that wasn't actually a crime for the people who committed it, right? Strictly speaking, because there was no law in their country against it. I think about the aggressive war as well, crimes against peace. Again, there was no law or international law that said you can't go to war with somebody else for any particular reason, right? Countries went to war all the time. So how do you retroactively go back and create this idea that not just our country is going to be liable, right? We had that. Think about, World War I, and the, Paris Accords and all that sort of stuff, where Germany had to pay so many reparations and all this money that, created the conditions that were rife for Hitler and the Nazi Party to take over, right? How do you actually, not just make countries responsible, how do you make individuals who are part of a political system that waged a war responsible? And even then, there was another challenge there that they had to confront, because not all the people on trial, or not all the players in the system, did all the acts that were necessary for war, right? You may have just played one little small piece in a political system that ultimately committed these crimes, but does that make you liable for everything? And that's why it's so important that count one was conspiracy to wage aggressive war, because that was the way that Nuremberg was going to try to make these leaders accountable, so that they couldn't just say, I was just following orders, or I only had, this little minor involvement here. They were trying to show there was a wider plan at place, when then right from the point that the Nazis overtook the German government and all the steps that they took leading up to World War II, that there was that common plan in place, and that each one of the players did one small action in furtherance of that plan. And that was a hugely significant innovation.
And they were actually not allowed to plead, I was just following orders, among other things. And even taking a look at First World War, Hermann Goering spoke a great deal about the problem with the reparations, and he was not keen on taking necessarily responsibility right at the beginning of his trial. He really wanted to go back to that and tie it all to World War I, which was really, really interesting.
That's what they were trying to do, is justify, say, look, that I'm not an evil person. This was a justified response to measures that had been imposed on us.
That's right. That's the whole defense.
Yeah, exactly.
And now we should really discuss, though, this famous, or should I say infamous, cross-examination of Hermann Goering. This was the culmination of the film, and as a matter of fact, it's often taught as a course in law school. I've seen it described as quote, the worst cross-examination in history. But I think it's rather uncharitable to call it that. It seems like it certainly was dramatic, though. I've read that during the direct, Goering was quite unrepentant. He was not evasive, which I think was what was expected of him. And he offered no apologies. And, I guess what the best thing you could say, I suppose, is that he was a formidable adversary. Now, he had his own lawyer, his German lawyer, who led the direct examination. And then on March 18th, 1946, Robert Jackson began his cross-examination. And Goering, I think at first, managed to deflect quite a lot of Jackson's questioning. And he provided these very, very long-winded answers that buttressed points that he had made on his direct. But later on, it seemed like Jackson did get to make his points. And I have to say that in Canada, we are used to the adversarial principle. But I think Justice Jackson had a hard time because he used a lot of compound questions, for instance. So I have a few examples, but if you want to give us any examples, feel free.
Sure. I mean, I'll start out by saying, I think we have to appreciate the Herculean task that it would have been to cross-examine Hermann Goering. So it's very easy for us to pick apart and to say, oh, why'd you say that? And why'd you do that? But, you're dealing with somebody who is quite literally, larger than life, right? There's a reason why these individuals, like Hitler, like Goering, were able to overtake a very well-educated country with, huge institutions, very significant institutions, and so forth. And it's because of the charisma and the gravitas that these individuals had, right? So I don't want to kind of undermine anything that Robert Jackson did. I also think that we have to bear in mind he was a Supreme Court judge as well, and you're probably used to being listened to when you're a judge as well, and not having people talk back to you and having people fight with you. And that was, I would think, probably a little bit of a new experience for him as well. But I think having said all that, what Justice Jackson ran into was one of the most common errors. And that's that you cannot get argumentative and you cannot quibble with witnesses. And we saw, so many examples of that throughout, where Justice Jackson is essentially trying to put suggestions, as you do in cross-examination, to Goering, and Goering is coming back at him and saying, well, no, that's not quite right, or that's not what I meant. And then, he would take the bait, or Justice Jackson would take the bait and try to engage with the argument over the meaning of specific words and specific terms, and so forth. And, there's one example that that stuck out for me of that, right? So there's this question that he asks, you have stated that on the Jewish question, some of the members of the government were more radical than you. Would you state who those were? So you kind of think, okay, well, number one, what is he really getting at there? But number two, I just think it through from a common sense perspective. You're essentially using very charged language there of some members were more radical than you. What does that mean exactly? When you say more radical than you, right? And that's a classic mistake in cross-examination where you essentially try to ascribe characterizations to things. Because anytime you try to do a characterization, a witness is going to get combative with you and is going to start fighting with you. So, a good example is let's say that you're dealing with a witness who, and you want to ultimately go to the jury to say that the car that they saw, speeding away from the scene was, going like a bat out of hell, right? And, the witness is, not necessarily going to be cooperative with you. So you try to put the suggestion to them. You were there standing on the street corner and you saw that car, going like a bat out of hell down the street. Well, they're going to say, well, what does that mean, a bat out of hell? No, I disagree with your characterization, sir. And then you've kind of been deflated, okay, right? But if you were to take a different approach and say, you saw this car, right? The car was going at least, 80 kilometers an hour. The car went through a stop sign. You heard the wheels, the tires screeching on the car. And, those are things that they couldn't necessarily disagree with, right? Because they're very factual based questions. And then you ultimately go to the jury and say, the witness said the car was going 80 kilometers an hour, the tires were screeching, they barreled through a stop sign. That car was going like a bat out of hell, right? You don't need to put the characterization to the witness. You put the characterization to the judge in your submission. So that's kind of a classic thing. And we saw Jackson fall into that, unfortunately, a few different times as well.
Yeah, I found it really interesting. There was this whole part where Jackson is trying to talk about setting the Reichstag on fire, right? Because Goering apparently was quite involved in this, and then he, set up the communists, right? And that's how, a whole bunch. That was at the very beginning, and a number of communists and others were shot. So getting rid of the opposition, and it was, I mean, I think it was something like 15 questions to get to the end. And Jackson never even got an admission at the end of it, right? At the very end, Goering says, nope, I don't remember ever saying that I set the Reichstag on fire. And Jackson at the same time talks to him about his co-conspirator, who was shot at much later. And wasn't even able to get an admission that this was because he was pointing fingers at Goering. And I mean, it's ridiculous to think that it takes so much time, and then at the end he doesn't get anywhere. And I think it's exactly that he uses language that's not precise.
Mm-hmm.
He compounds these questions, and several times Goering says, "Well, that's 4 questions." And begins to school Jackson on that question. Okay, now question 1.
Yeah, exactly. And the most effective cross-examinations out there are where you don't even have to put these ultimate suggestions in a lot of ways, right? Because, again, like Goering, like he's not a cooperative guy. He's not going to give you the answers that you're looking for in an easy way, right? You're not going to be able to just say to him, well, you burned down the Reichstag, and him, yes, you got me. Like, as we often say in cross-examination, there's never any Matlock moments, right? It's never as easy as it is on TV. So, sometimes you have to like take a different approach in cross-examination. And, it's great when you can, be all precise and, just put these suggestions to you and then, they agree with you. But sometimes you can just have a way of approaching it where you're just using certain language or, building it up in a certain way, and everybody's thinking exactly like what the answer is. And then it doesn't matter whether they agree or disagree with you at the end of the day, because you've already made the point without actually having to speak those words, right? Like a good example might be if you're cross-examining somebody who's, you think somebody's mother is coming to testify in their son's defense, right? Like, let's use that as an example. And, you wanted this idea that, they're a loving mother and they're just coming there to help out their son, right? You can put questions to them, like, you're a loving mother, like who's going to disagree and say, oh, I'm not a loving mother, right? Like, you're close with your son, you want to, you help out your son, again, like no parent is ever going to disagree with that. And you kind of have like a series of questions like that. And then you don't actually need to put the suggestion to them and say to them, well, you're just coming here to help out your son, through your testimony, because everybody's already thinking that, with like, oh, she loves her son, she does things to help out her son and so forth. And that's what, in a lot of ways with Goering would have been a very effective strategy, is that you build up this idea, because he's such a, grandiose narcissistic figure that, he has his fingers in everything. He was the one who had this grand plan after the Treaty of Versailles. He was the one who, knew Hitler personally and was Hitler's like right-hand man. You kind of build that up so that everybody's thinking, well, of course he would have been involved in these decisions. There's no way that he would have been involved in these decisions. And then you don't need to get into these little quibbles about like, oh, you were on the meeting minutes here, right? I see you there. And then he goes, well, yes, I'm on the minutes, but, I was actually there for half the meeting. Or, oh, yes, that's improperly, translated. I quibble with you whether it should be interpreted as the final solution or as the total solution, right? So
yeah, very distracting, right? I mean, to the triers of fact, to have the witness quibble about terminology that essentially means the same thing, right? And it's interesting. And, Sir Maxwell Fyfe, the British prosecutor, actually did a really good job. And he actually really used a lot of the, like this concept of show, don't tell, right? Which is helpful. And I thought that was a really interesting counterpoint to the way that Jackson had been cross-examining him. But listen, let's get back to a few more examples. I know you have some, and I'd love for you to go through them.
Sure. So one other example is here. There was a whole thing about points of the cross-examination as to whether Jewish people within Germany could claim damages, right? So as we all know, the terrible night of Kristallnacht, where Jewish businesses were destroyed. Well, as you can imagine, businesses have insurance. And then there was a whole question as to, okay, well, aren't they just going to claim insurance? And, this being Nazi Germany didn't want, the Jewish people to have money or to get money from, German companies, right? It was felt that, well, they're robbing Germany if they do that and so forth. And, part of the cross-examination was focused on how it came to be that a decision was made or that, to deny people the claims under the insurance, because the insurance companies were saying, we're under a contract, right? We have to pay these claims out. And the government didn't like that, right? They were trying to find a way to basically make it look like the claims are being paid out, but denying people access to the money that was rightfully, lawfully theirs. And then at the same time, also not making any other businesses worried, saying, these laws are just going to be changed on a whim and so forth. Right. And so there was a whole part of the cross-examination where, again, Justice Jackson gets into the minutes of a meeting where this was decided and the debate and the discussion that was going on. And he kind of ultimately puts this, suggestion to you or to Goering about, well, you essentially agreed with this idea that, the money wasn't going to be paid out to Jewish persons in Germany. And, Goering kind of like says, no, hold on. I disagree with that. I was going to pass a law, right? I didn't want to just surreptitiously, confiscate it. My intent was here to pass a law to make it such that they couldn't get the money, right? And, again, it's another example of, all you kind of had to do was show, Goering is at this meeting. This whole topic is going to be discussed. He's, the second in command, these are the worries that are going on. You don't actually have to get into like a line by line examination of the minutes in order to get everybody thinking that, that was the intent here, was to deprive people of what was rightfully theirs, right? You can do it in a way that didn't get into the minutia of saying, well, didn't you agree with this person? And do you agree with what the minutes say here at this point? Because that opens up all these, opportunities to just get into these, little back and forth exchanges about what it all means. So that's like another example where you can just so clearly, in my view at least, show that he was involved in this decision, that what this decision was all about, without actually putting that ultimate suggestion to him, because of course he's going to disagree with it.
Yeah, I mean, you're right. He doesn't need to put the suggestion to him at all.
Yeah, exactly. Because you're painting a picture. I mean, that's a lot of what cross-examination is. You're trying to paint the picture because, again, you're never going to get that Matlock moment. And you want everybody thinking exactly what you're thinking, right? That there's just no possible way that, he wasn't involved in any of this. So that even if you do make that ultimate suggestion and he disagrees with it, like it just sounds so unreasonable.
Right. And it shouldn't matter whether he agreed with it or didn't agree with it, since he was part of the team. And I think what Jackson failed to do is what we sometimes call build the box.
Yeah, exactly. Build the box, right? You get people you set it all up so that no matter what the answer they say, it's a good answer, because ultimately, what are they going to do? If you build them in, they're going to agree with you, and then you have the admission. Fantastic. But if they disagree with you, you built them put them in the box so that they look unreasonable. And that is good with Maxwell Fyfe, because he kind of played on this idea that, Goering was, the second in command and so forth. And he was second in command, like when all these key consequential things happened, right? So again, everybody's already thinking like, there's just no way that he can claim ignorance about this sort of thing. So, if there's the ultimate suggestion is put to him, right, that you orchestrated this, you were involved in this and so forth, and he says, no way, how is that reasonable? The second in command, who was the right-hand man, who was, there from the beginning, just no way. That's not possible. So yeah, you box them in, and then it doesn't matter what answer you get.
All right. Do you have any other examples before we get to the root?
The other example that came to mind for me was, again, this idea of you don't get into arguments about terminology. So there was one exchange here about state orchestrated violence towards Jewish people in Germany, but there was also people who took it of their own accord to commit acts of violence against Jewish people.
Here is Mr. Justice Jackson. We now come to the cases of the killing of Jews where proceedings were suspended or minor punishments pronounced. I will not go through those in detail, but it is a fact that only minor punishments were pronounced by the Supreme Court of the party for the killing of Jews, were they not?
Yes, that is correct.
I now ask you to turn to page 8.
One moment, please.
I call your attention to the language in regard to cases 3 to 16.
Which page, please?
9, I believe it is. The Supreme Party Court asks the Führer to quash the proceedings in the state criminal courts. Göring, to quash them, to beat them down, that does not mean suppress. A penal proceeding can be niedergeschlagen. In Germany, that is a different thing from suppress. Well, you give us your version of it and tell us what it is. What does beating down a proceeding mean? Does it mean that it has ended?
That is what it means, but it can only be ordered by an office which has authority to do it. That is to say, the Führer can at any time beat down a proceeding by way of an amnesty. The cabinet could at any time pass a resolution to beat down a proceeding. Suppressing it would have been illegal. In Germany, niedergeschlagen is a legal term to suspend. So that's like a great example there, because you see Jackson essentially, and this is one of the, like, unless you boxed in the witness, so it doesn't matter what answer they get. You have Jackson actually saying to him, what does this mean? Give us your version of it. What does beating down a proceeding mean? Does it mean it has ended? And, for somebody like, any witness who's in an adverse interest is going to relish in that opportunity to completely explain or expound or justify or whatever it is. So you kind of question, like unless, you have, as we said, completely narrowed it down. So it doesn't matter what the answer is. Why would you ever give that opportunity for a witness to explain, right? Cross-examination is about denying witnesses the opportunity to explain. And, we all would love it if they just stuck to yes or no answers, but obviously they don't. But you want to try to minimize the non-yes or no answers, right? And even then you get into this whole debate because, beating down a proceeding, I mean, that's by definition a very equivocal term, right? Why are you asking, what does it mean? Why are you not putting a suggestion to him about this is what it means, in the legal sense, because you've done all your homework and you've come up with a very specific definition that comes from the courts. So, again, that's just a good example of, don't rely or don't use things that are open to interpretation. Don't give that opportunity to expound, and avoid those characterizations, and do the lead up, to those that question, so that, you basically cut off all these exit routes, and there's really only a very few prescribed answers that they can get that would make any sense. And if they don't give those answers, then everybody's thinking the witness is incredible. They're lying.
Yeah, I would say that throughout the transcript, Jackson gets frustrated and, tells Göring to say, here's a quote, if you would just answer 3 or 4 questions for me, yes or no.
Yeah.
And I would be quite willing to let you give your entire version of this thing. And so it's ineffective, right? I mean, structure is what's effective.
Exactly. It's structure what's effective. And also, one of my mentor always said that you have to be in control of your emotions when you're cross-examining, or just, in any part of the litigation, right? You cannot let your emotions be in control of you. You have to be in control of them. And when you let the emotion out, it's because you want the emotion to be let out, because it's an effective form of advocacy, right? So you're not being frustrated because you actually are frustrated and the emotion is speaking before the reason, right? But if you're expressing frustration, it's because it's part of your litigation strategy or your advocacy to let the court show that frustration, so to share that frustration, so the court admonishes the witness, or everybody feels that frustration because the witness isn't answering the question. But if you let the emotion govern you, then people are going to be focused on the emotion and your frustration than what the actual answers from the witness are.
That's a really good point. So on July 26, 1946, Jackson made his closing argument. Göring was apparently, I guess they were all sitting in the dock. And apparently he kept count of references to him in the closing argument. And then many months later, on October 1st, actually, the verdicts were read and Goering was sentenced to death by hanging. And I read that upon his sentence being read, Goering turned and left the courtroom with no expression. And just as a point, all appeals were rejected. David, what lessons do you draw about human nature from Goering's performance on the stand and as a defendant?
So, it's interesting because I think the ultimate lesson, or one of the lessons, I'm kind of coming at it from like a litigation perspective, right? Is you have to know the person that you're up against in cross, right? And you have to kind of use that to your advantage to some extent. So, it's kind of like when we talk about some of the contemporary circumstance as well, right? Like, if we're learning to stroke somebody's ego because we know that somebody likes their ego to be stroked, right? You can use that to your advantage, right? It's kind of like what we were talking about, a few minutes ago. Goering is this larger than life figure who was the second in command. You build that up because he's going to want to talk about all that stuff. And that's how you box him in because, he wants to make himself out to be the big shot, right? So that's kind of one aspect of human nature is you play to, how people want themselves to be perceived. And then even when it comes to, him storming out as well, I mean, again, it just goes to show, right? Like that it's all about him. It's not about, anything larger than that. And that's kind of a tool that you could have used to your advantage throughout the course of the proceedings. One of the most striking moments for me that I've read about at the Nuremberg trials, it goes to show, advocacy because, again, like, Goering was playing a part. He was acting through his answers. He was acting through his mannerisms. He was acting when he stormed out. But I thought this was the best piece of advocacy, or one of them for the prosecuting powers, is the probably one of the first examples of using film in the course of proceedings. Right now, it's common to use video evidence, but back then this was a real innovation. The Americans had made a movie upon liberation of the death camps, and you can imagine the horrific scenes that were shown in that. So they had to set up this projector, they had to set up a screen. But it was very important to see the defendant's reactions during this, right? So what they did is they had this. You had to lower the lights, obviously, so you could see the full projection on the screen. So the courtroom was darkened, but they actually got spot lamps that was directed at the box for the defendants, and just to capture their reaction. So picture, everything else goes dark, and then these lights come up just to capture the defendants, right? And then this video is played. So everybody's watching the video because that's lit up. Everybody's watching the prisoner's dock because that's lit up, right? And just the reactions. Goering apparently just sat there and closed his eyes during the entirety of the video was showing, right? Rosenberg apparently started like shaking back and forth, right? And it's interesting because I really do believe that people will ultimately try to control their actions and their answers based upon how they want themselves to be perceived. But just think about what that's like if all the attention is suddenly focused on you, right? And it's your actions, your facial reactions, and all that sort of stuff that is being scrutinized in minor detail. Like what that would be like, and how that would you can't then shy away, from it. You're literally under the spotlight at that point, and you can't control how people are perceiving you at that point because you were the sole center of attention.
David, have you ever had opportunity to use a similar technique in any of your trials?
Gosh, I don't think I've been able to use that. That would be a little dramatic, but it is always quite remarkable when you have the one key piece of contradictory evidence. And, that happens so very rarely that you get something that just totally contradicts. Like, we're not talking about like minor things. Like, we're talking about whether somebody says like, I was in New York City that night, and you have incontrovertible, dramatic video footage of them being in Chicago that night, right? So it only happens, or this has only happened a couple of times. So one of the ones that specifically stands out in my mind was somebody who had said that they were on the street when this shooting of an individual took place. It was a murder trial. And, they said, yeah, I saw, this person come forward with a gun, I saw everybody scatter and, et cetera, et cetera, et cetera. Right. And we had incontrovertible evidence that showed that they were actually upstairs in their apartment. And, so they went on this big, long thing. And again, it's about boxing them in. So you say you were there, you were on the street, you remember the sights and the sounds and the smells, and you remember this person being here, and you remember vividly, the color, of what the person was wearing and what direction the person came from. And, all those very vivid observations, and then showed them the video where they were walking into their apartment, like just minutes before the shooting, which would make it impossible that they had seen any of that. And just seeing, the reaction on their face, right? Because they want to portray themselves as like, I'm the good guy. I'm the one who's trying to help out my friend who was shot and all that. And then just to see kind of the withering reaction. And, people have reactions where they get mortified. This guy just put on the biggest smile on his face when he realized he had been caught, right? And then, it's done at that point where his evidence is just totally discredited. But that so rarely happens, in our courts.
Exactly. It's not quite the scale of what we're talking about today.
No, sure.
But it's so interesting talking about this. Thank you so much for speaking with me. It's such a heavy topic and so instructive on so many levels. And I think everyone should go see this film.